to the video that we posted the other day was, hey, these are dangerous individuals. A pandemic would, trump any constitutional right that a person has. I think what I want to try to stress is that, I am somewhat of a realist. Like, I recognize that there are competing interests when we're dealing with the criminal justice system. And, if I go before a judge to make an argument, I want it to be something that is going to ring true or that judge is going to understand is important. And so I'm not, I try not to file motions if I think that they are just blanket motions that are going to be denied. Obviously, as an attorney, I have an obligation to essentially, not file a frivolous application with the court. So one of the things that I thought was an interesting response that I wanted to talk about today was this idea that perhaps individuals, if they're going to be released right now, maybe they should have to be tested before they're released to confirm that they are not positive. I think that's probably not a bad idea. I think that could be something that the courts could order. And in fact, in the order that came out last week, releasing certain individuals who were serving county jail sentences, the court said if they've tested positive, they can't be released. Now, that order didn't order their testing before they were released. So, to counter any concern by individuals in the public that the release of inmates as a result of this coronavirus could cause community spread, that might be something that would be a reasonable thing for a court to order. There may or may not be, HIPAA, ramifications or HIPAA issues that need to be dealt with there. But obviously, if an inmate wants to be released, they would most likely agree to undergo that kind of a test. The other thing, though, that I think is important to point out, and that is, we got to this towards the end of the video the other day, but I think it's really significant. I'm not necessarily advocating for, everyone that is detained to be released. What I think really needs to be considered is this idea, though, that there can't be endless excludable time. In other words, there has to be something that the courts put into place so that the individuals that are detained without bail are not just sitting with their speedy rights being violated, speedy trial rights being violated. So that the other day, but I don't think that much is going to change come April 26th, which that the court has determined is this consistent end date. Again, if I'm a prosecutor right now, I would be concerned that if things don't change fairly soon, they could be in a position to be releasing individuals that have that are at their 2-year mark. In other words, the criminal justice reform gives a maximum 2-year date before individuals have to be released, even including the excludable time. So the question becomes, shouldn't prosecutors also be concerned with the fact that there might be individuals who are coming up against that 2-year mark, and because of this court closure, they're going to have to be released, even with the excludable time. Does that make sense?
Those are the breaks, counselor. I don't know what to.
Well, right, that's
but I do think it's. I mean, in the scope of things, how terribly concerned are they about that? I mean, that's somebody who presumably, even if you let them out, they're on the short list to come back when a trial starts. What percentage of those people are, mass murderers or the type who, they're probably not candidates for release anyway.
Right, and that's exactly the response. I would imagine that the the response would be that, again, there are, given this worldwide pandemic, this is a force of nature that we've never seen. They're just going to have to wait to get their day in court, and that their Sixth Amendment right to a speedy trial is going to be trumped by that. The courts can continue to grant excludable time and not in the back of their minds be concerned about that 2-year end date that will require them to consider releasing very serious individuals that are charged with very serious crimes. So, that's something I think is important to talk about. And
it's interesting to have you at least point out, well, there is an instance here where we're going to be letting murderers and rapists go, because the 2-year line, that's a constitutional, line in the sand. That's not particularly,
right.
I would think if you start breaking that, you'll have lawsuits the next day from constitutional lawyers and civil rights attorneys and things like that. As soon as you start bending rules like the right to a speedy trial, you said earlier, I'm a realist. And what as a non-attorney, when I hear I'm a realist, I hear there goes the Constitution, because what you're saying is, guess what? This isn't going to be an easy black and white solution.
No,
it's going to be a very human solution. It's going to take time. So if it's for somebody like me who's too daft to think in subtleties, and either it's constitutional or it's not, I'll just have to look away.
Right. If an individual has had no experience with the criminal justice system, and they read in the paper that people that are in jail are going to be released, individuals out in the community don't want to hear that. I get that. But the minute someone has someone close to them who's been charged with a crime and charged in their mind unfairly, has been in their mind overcharged, then their stance changes significantly. And so, I've seen it from both sides. I worked for the majority of my career as a prosecutor, interacting on a daily basis with victims of crimes and family members of victims of crimes. It's understandable to think that they would not want inmates released for any reason. But again, now that I have this perspective as a criminal defense attorney, and I've had a number of clients who have ended up being found not guilty of a very serious crime that they were charged with. I just think that prosecutors, the general public, have to recognize that there are competing interests. And it's those competing interests that our whole United States legal system was premised upon, right? It's an adversarial system. It's state has to prove their case beyond a reasonable doubt. Scales of justice balance community safety versus individual rights. So we can't just throw all that out the window. We have to at least discuss it. And that's what I think we need to think about. And I'm sure the courts are thinking about it. I'm not suggesting that they aren't. But for individuals in the community that instinctively backlash against the idea that people might be getting out of jail, or that we have to have some sort of a change, I think that they really need to think more realistically and try to think about it in terms of, hey, all right, I'm willing to play devil's advocate, and I think everyone should. Everyone's got to consider the possibility that this could be them, and how would they want to be treated. And, that's really what it comes down to. And I think that's what the court is attempting to do. You said it the other day that this time between now and April 26th is probably the courts trying to figure out, what the next step is. But I think that, the public at large also needs to recognize that there are these competing interests.
Yeah. And that's kind of like who it was Clarence Darrow or somebody, where it's, you'd rather set 1,000 guilty men free than imprison one innocent person.
That's what our whole system is based upon.
And I'm inclined to agree. I can't imagine a torture worse than somebody who knows they didn't do something, finding out now that they have to maybe be behind bars for an extended period of time for a crime they, in their heart, are fully aware they didn't commit, and it's all due to a global pandemic and a shutdown of the court system that prevents them from being able to tell their side of the story. And now they're freaking out because when they get that opportunity, will it take place on a level playing field? What will the environment be when they do get their day in court is something that they should be equally concerned about, or at least I would.
I don't know how long it's going to be before we can impanel a petit jury and have a protracted jury trial where individuals in the jury are interacting in close quarters on a daily basis for sometimes weeks at a time. That's, I think, under where we are today, it's going to be a while before that happens again.
Sure.
So I don't know how the courts are going to ultimately respond. Individuals have a right to be tried by a jury of their peers, and if you're following the news, I don't see a situation where we are going to be able to have that happen anytime soon. And remember, in New Jersey, at least in the counties in which I practice, the courts dockets are full. They're very full. I mean, as it stands right now, and I primarily practice in Atlantic, Cape May, and Cumberland counties, the courts prioritize jury trials for detained individuals. Obviously, they're the ones that get tried first. And there's only a certain number of criminal judges in each county. And a trial could take a couple days, or it could take a couple weeks, or it could take a couple months. And those judges that try those cases, they don't always try them Monday, Tuesday, Wednesday, Thursday, Friday. They try them a few days a week because they have other cases that they have to manage. But the AOC in the state of New Jersey makes sure that the judges in each vicinage and in each county are prioritizing those detained cases. So when we do come back to a situation where we can have petit juries, there is going to be a very big backlog of cases.
Can I throw a couple just for fun hypotheticals at you from the mind of somebody who knows nothing about the law?
Yeah. But you shouldn't be playing devil's advocate with me, because
what if I'm a defense attorney, or if a single juror brings up the word coronavirus, or I can't wait to get out of here, or want to get home to your family, I will appeal the shit out of any verdict that comes out of that jury room. If I can get proof, if I can get a statement from a juror to the...
if I am representing an individual and we are towards the end of a trial, and my client is convicted by a jury, and that individual later finds out that the jury just wanted to get out of there because they were afraid of perhaps having been exposed for whatever reason, it's going to be an appealable issue, certainly. At least it could be. So the question then becomes, what do we do? What do we do that ensures fairness to both sides? What do we do to ensure, fairness to the state and its ability to protect the community and try its cases? And what do we do to protect the rights of individuals? That's really what needs to be considered. And I don't think that we're going to have the answer to that on April 26th, when the courts in New Jersey have indicated that because that's a consistent end date, we're going to be back in court in in-person proceedings. I don't see it happening.
Another question. What, with New Jersey's courts are shut down, what interplay generally exists between one state and another state? Does being neighbors with a state whose courts are shut down affect you as, Delaware?
No.
Pennsylvania?
No.
Is there not enough?
Not at all.
Okay.
No, I mean, I think that the courts certainly, consider what's going on across the river, but they're separate and independent court systems. And so
all the bad guys from Jersey were hiding in PA, and all the bad guys from PA were hiding in Jersey.
I think to the extent that we look to other courts for guidance, but it's not binding. There's always both prosecutors and defense attorneys might rely on what's happening over in Pennsylvania to support a position that they're taking.
Sure.
No, nothing that's happening in PA is binding on any court in New Jersey. The only thing that's binding on the state courts are the decisions by the U.S. Supreme Court. The U.S. Supreme Court is the highest court in the land, and state courts can and often do provide greater rights to their citizens than that citizen would get under federal law, but they can't provide less rights than that individual gets under federal law. So U.S. Supreme Court is the Supreme Court of the land. The U.S. Constitution is the supreme law of the land because of the Supremacy Clause. So the only thing that's binding on New Jersey courts are decisions by the U.S. Supreme Court.
That seems fair.